and good afternoon to everybody. My name is Philip Martin. I'm an attorney at LegalAid of Nebraska. And I wanted to, first of all, just say thank you to the Nebraska Council on Economic Education and just do a shout out to the wonderful work that you're doing. I wanted to say thank you to Matt Pearson and Jennifer Davidson. It's been wonderful working with you the past several months, and I can't thank you enough for your efforts in helping put all this together. Well, guess what I'll do? I'll just go ahead and first of all dive right into the PowerPoint we have. Just a second here. All right, everybody can see that. So again, like I said, my name is Philip Martin, and I'm an attorney with LegalAid of Nebraska. LegalAid of Nebraska, what are we? We are a nonprofit organization, and we help low-income individuals who are experiencing issues with civil legal matters. We do four main areas of practice: housing, children and families, debt and finance, and income and benefits. I've been with LegalAid of Nebraska since 2017, so I've honestly had a chance to do a little bit of everything over the years. Mostly what I've done during my time here is I've spent most of my time with the debt and finance unit, and I've also done quite a bit with income and benefits as well. But what I want to talk to you guys a little bit about today is I want to talk a little bit about debt collection in Nebraska. I feel like there's a lot of misconceptions out there of what debt collectors are allowed to do, how debt collection works. I think a lot of this is perpetuated by the debt collectors, but I think a lot of it is also just due to people who are maybe not familiar with what the situation is, and they just kind of provide their own opinions on the matter. But what I want to talk to you a little bit about the process and hopefully dispel some of those myths. And then also I want to give a little bit of advice on how to help people who are low income that are going through debt collection. Discuss with you maybe a possibility they don't need to do anything, or maybe if they do need to do something, is there a certain way that we can go about paying down these bills? And then I also want to take a little bit of time talking about some specific creditors as well. But what I want to do very briefly is I want to talk a little bit, just kind of a brief overview of Nebraska. Here in Nebraska, it does tend to have a lot of laws that do make it a very creditor-friendly state. The filing fee is very low. A bill collector can purchase debts from a whole bunch of different organizations and lump them all together and sue them once, whereas other states don't allow that. They require it to all be related. Also, it allows debt collectors to sue under their own name, so the original creditor can save their reputation a little bit. We also have different tools like debtors examinations, as well as bank account garnishments and wage garnishments simultaneously, which again can allow people to collect on their debts. This slide I want to just kind of show very briefly. What this slide does is it just demonstrates a breakdown in county by county by poverty level. And what you'll notice is that the areas where the poverty level is much higher, there's a large concentration of debt collection cases that are filed. Also, you can see where it says the average judgment amount, we're not talking about a lot of money. We're talking an average judgment of about $1,500. So ultimately, when we think about it, these are individuals getting sued over struggling to pay a $1,500 debt. That's the type of people that are getting sued in Nebraska for not paying bills. So when somebody comes to you and says, I'm getting sued, or I'm struggling with all these bill collection companies, what do I do? Now, sometimes, if you can thread the needle just right, the answer is nothing. The old expression, you can't get blood from a turnip. So maybe you should first ask yourself, am I legally a turnip, right? Well, what would happen with the debt collection? Well, at some point, they might take it to an attorney. The attorney might take it to court. They might get a judgment. What's a judgment? A judgment is just an order from the court that says, yes, it's a valid debt, and yes, you can try to collect on it. Maybe they can collect on it, maybe they can't. There's a lot of worthless judgments out there. How do creditors end up collecting? So the first thing they usually try to do is figure out where you're working. Because if they can figure out where you're working, they can take up to 25% of your wages, 15% if you have dependent children, and they can just keep that going week after week, month after month until that thing's paid off. Now, sometimes you'll have a client who isn't working at all. Maybe they're on Social Security or maybe they're currently unemployed. Well, from a debt collection perspective, I can't really get any wages. So we need to look at the next step. Is there any type of property that maybe a person has? And if they really don't have any property at all, then essentially you can't get blood from a turnip. One thing that I hear a lot is a lot of times debtors come in and they're very worried. They're very nervous. Am I going to jail? And the answer to that is no. We've done away with debtors' prisons 200 years ago in this country. You're not going to jail just because you failed to pay a civil legal bill. Okay? If missing a credit card payment is something that'll get us thrown in jail, at some point, all of us are going to be in jail. And that's just simply not true. So, what can they do? We talked a little bit about wage garnishment. If you don't have wages, what's the next thing they often try to look at? Well, maybe if you have some type of a bank account and they can figure out what that is, they could try to get that. A lot of times I do find we can object and get most of that back. Again, you can't garnish certain types of wages like Social Security, VA benefits. And then I showed this next slide here just to show that in Nebraska, we have several other laws that protect other types of property. Usually the big ones that people have are a house and a car. Unless you have at least $120,000 in the equity of a house, they're not going to be allowed to sell it for non-payment of a credit card bill or medical bill. A car up to this used to be a reasonable number, but they would adjust it for the cost of living. So now it's closer to about $6,000, about $3,600 for household goods. 401k fully protected, health aids fully protected, and then they give you another almost $6,000 to keep any other property that you might want. And so unless you have at least $6,000 in a bank account, for example, there's probably nothing you can get. So a lot of times we'll have a client, maybe they're on Social Security. They maybe drive a car, don't have in a little car, and don't have one at all. They rent their apartment. And at that point, if you're a creditor, what are you going to get? And the answer is probably not much. Unless the person willingly hands it over, there's probably nothing you could ever get from the court system. So at that point, I like to tell my clients, hey, look, you're what they call collection proof, right? All they can do is make noise and howl at the door, all right? But unless you willingly hand it over, they're not going to get anything at all. And then once they realize, hey, all they can do is make noise, at that point, I tell them to, tell these creditors to knock it off. Now, under the Fair Debt Collection Practices Act of the FDCPA, if you notify the creditor that you don't want to be contacted again, they are required to stop contacting you. They can actually, I guess, contact you one more time just to tell you that they're going to be taking it to an attorney. But other than that, they need to stop. I usually recommend putting it in writing, either through an email or through a letter. That way, at least there's a paper trail. But that's always kind of fun because if they do contact you again, then you can sue them under the FDCPA and get $1,000. It's kind of nice. It's not a ton of money, but there's just something about when somebody calls you up and says, hey, you owe me money. And then you turn right back around and say, no, actually, you owe me money. That's just kind of a nice little change of scene. So I tell the clients, look, let's set up a realistic budget and understand that not all bills are created equal. Okay? Now, at this point, I want to just kind of clarify what I'm talking to people. A lot of times I think people misunderstand a little bit of what I'm talking about. I'm not saying that, hey, you found a loophole in the system, or hey, you gamed the system here. Here's how you can win it. But rather, if this was a perfect world, everybody would have enough money every month to pay every bill every month. Okay. But unfortunately, that's not always the world we live in. And if you don't have enough money every month, you're going to have to pick and choose. So how do you pick and choose who's going to get paid and who's not? My rule of thumb, if they can kick you out, take it away, or shut it off, you pay those ones first. Pay your rent, pay your mortgage, or you're going to get kicked out. Pay your, um, your car, or they're going to come take it away. Pay your utilities, or they're going to be shutting that off. Everybody else, your credit cards, your medical bills, your payday loans, they have to go to court. They have to go to the judge. At the end of the day, if you don't have anything to take, then they're not going to get anything. If at the end of the month you have enough money to pay them in full, that's terrific. But if you only have $5, pay them $5. If you only have $0, sorry guys, but those are the rules. And in all fairness, they knew that they were going into it. So I hope that kind of explains a little bit about what to do when you find an individual who is essentially what they call collection proof. Now, a lot of people are not collection proof. Maybe they are working. They do have garnishable, or they do have a property that might be worth more than they would care to lose. Well, if that is the case, then again, what I still recommend doing is my rule of thumb. They can take it away, kick you out, or shut it off. You pay those ones first. Everybody else, do what you can. So let me talk a little bit about what would happen if it ended up going to court. I want to discuss a little bit about how the person might want to handle that. And then I also want to spend just a little bit of time talking about specific types of cases. I want to talk about what to do with the garnishment, talk a little bit about student loans, medical debt, scams. I want to talk a little bit about it just because we have had a lot of issues with that, it seems like, in the last year or so. And then a little bit about mortgage delinquencies and bankruptcy. So again, my biggest thing with my advice for my non-turnips, budget, save, of course, just kind of the standard advice there. Always double check your itemized bills. If you don't owe it, dispute it, bring it up, challenge it. Even if you're not sure, if you bring it up and question it, the worst they can do is explain it or say no. One of the challenges I often find with representing low-income individuals in consumer cases is not really so much whether it's owed, but usually the question is more how to pay it. I would say easily 90% of the time somebody comes in with a bill, it's really not a question of if they use the credit card or if they obtain the medical treatment. It's really more an issue that the creditors are demanding a payment that is in excess that they can pay, or demanding such a high balance that there's really no realistic way that it's going to get paid off in any reasonable period of time. Now, if a debt is valid, then a lot of times at some point, and I hate to kind of say this, but it really comes down to either you got to pay it, you got to negotiate it, or you got to maybe discharge it in a bankruptcy. Again, with a couple of exceptions we'll get to in just a little. My big recommendation is don't ignore them completely. And if they are demanding $100 and all you have is 20, send them $20. What do you think is going to happen? Well, I would bet probably what most people do when you offer them $20. Pretty much guarantee they're going to take it. And I can't guarantee that they're going to avoid taking it to court. But usually I just find that if a person is, if a dog's well fed, it's going to be a little bit less likely to bite you. And I find if you just give you a little bit of partial payment, that can at least be a way to help you buy yourself a little bit of time. Again, negotiate. Review it, make sure you know what you're paying, and if you need to, send a dispute letter to the FDCPA. Now, again, one of the issues with low-income individuals is that most defendants in Nebraska who owe a debt are unrepresented. If they can't afford the $1,500 credit card bill, there's very little chance they can afford an attorney at all. Again, most of them really don't have much of a defense. It's not a question of if they used it, but it's more a question of how do they pay it. The other thing is many debtors are not aware of the process of Nebraska, the legal process, excuse me. So when they get a complaint served on them, they don't know what to do. Well, I'm going to tell you a little bit about what you do. When you get served with a complaint, you have 30 days to file what's called an answer. And if you can't find representation, I recommend getting at least what they call a general denial on file to help buy yourself a little bit of time. I have a link right there in my PowerPoint that I've provided. You can click right on that, search general denial, and that's something that you could fill out and file with the court to at least notify the court about whether you intend to contest this case at all. Now, one of the challenges that my clients often have is that if they were to file an answer, I'm sorry, if you don't file an answer within 30 days, you'll get a default judgment. But if you do, then a lot of times the creditors really turn up the heat a little bit and make things even more confusing. Oh, now this is actually kind of a shameless plug, I guess, to the court's website, and there's a link here to Law Help Nebraska. That's a site on our website that people can go to help them fill out these forms. But going back a little bit to what the creditors will do is they'll send them large packets of discovery, requesting information, requesting what are called interrogatories. That's just a very fancy word for questions and answers where you want people to draft up written responses. But they'll do this in a way to try to confuse and intimidate my clients, and in hopes that they basically roll over and give up and lose. Now, while a lawsuit is going on, I always recommend it's a good opportunity to at least reach out and negotiate. So often I've been asked by clients who are trying to contest this themselves, and they say, is it okay if I reach out? Yes, absolutely. Now, keep in mind, at this point, there are going to be some challenges. A lot of times, trust has long since been lost. This person has been missing payments for a very long time. And, I promise I'm going to pay it this time doesn't usually go very far. A lot of times creditors become very unreasonable. They become, agitated and start making demands that are well in excess of anything reasonable that the client can pay. When dealing with negotiations, sometimes it's a good idea to offer a payment plan, sometimes a lump sum, but most of the time clients come to me, there's really nothing in the bank account to even begin talking about lump sum. And when trying to offer something for a payment plan, many of the low-income clients I have never even put together a budget anytime recently. And I don't mean that disrespectfully or negatively. I just mean that as a factual basis there. Also, in negotiation, if you have a very strong position, it can often be a good way to make sure that the other side agrees with the offer that you're making. But a lot of times, again, my clients don't really have much of a legal defense. It's just more of a mathematical or financial problem. And so that can sometimes be a little bit of a struggle with negotiation. So my biggest recommendation, if you're going to negotiate, make sure you understand what your budget looks like. Maybe even save up a little bit just so you can have something to offer for a first-time good faith payment. And you're usually better off not making a deal at all than making a deal that you know darn well is going to fall through, because that doesn't help anything. And if you've got to go right back right after you negotiate, good luck getting anything going forward. So now I want to talk to you just a little bit about handling specific types of debts. I want to talk a little bit about garnishments, a little bit about student loans, mortgage delinquencies. Actually, I'm going to jump to the mortgage delinquencies at the end there. I'm sorry, this slide's a little bit out of order. Medical debt and scams. I don't know if that quite fits there, but I do have another presentation on scams, and I just wanted to talk a little bit about it because that's been a real problem that we've been having lately. And then I want to kind of finish up a little bit with bankruptcy. So let's talk a little bit about wage garnishment. What exactly can they do? So often I'll have clients coming into me, hey, this creditor has been threatening to garnish my wages. I can't afford my paycheck to go down to zero. Well, they're not allowed to take the paycheck down to zero. In Nebraska, you can take up to 25% if the person has no kids, 15% if they have dependent children. If for some reason the creditor messed up, they said, I don't think this person has kids, and they do, easiest form in the world. You just file what's called a request for a hearing on garnishment. I put a link right there on the PowerPoint. You just basically put in your name, you check the box that says, I am the head of household. You file it with the court. The court assigns a date for a hearing. You show up to the hearing and you say, Your Honor, I have kids. And it's really not much harder than that. Easiest hearing you're ever going to go to. Now, if they end up garnishing a bank account, it's a little bit different. You still have to do a request for a hearing, but you're also required under 25-15-52, the law there, to fill out an inventory list and what's called a notice of exemption. And at that point, I usually recommend giving us a call. We can help you fill that out. They're not terribly hard. It's just easy to mess up. And again, it's the same form, but I don't like the way that the court's form is set up. And so I just might just as soon say, give us a call and we can fill that part out. Now, after a creditor has tried for a while to try to collect, they can't figure out where you work, can't figure out what property you have. At some point, they might ask the court for what's called a debtor's exam. And that's where they request the court to order you to come in to testify about, where you work, what type of property you have. Now, if you don't show up to this, you can be held in contempt of court. And if you do that repeatedly, the court could even issue what's called a bench warrant to basically have the police come get you, arrest you, and take you into court. It's the closest thing we're going to have to debtors' prisons. And I really have mixed feelings with it. I really don't like seeing people getting arrested for not paying a credit card bill. I also kind of understand that at some point the court does need to have the authority to force people to come in, but it's just a situation I really don't like seeing. Fortunately, again, I've been here for almost 8 years. I think I've seen it once or twice. So show up to the debtor's exam, especially if they're the client's collection group. Because the only thing that's going to happen is you're going to go in, you're going to testify that you don't have anything that they can take. And it's going to be the easiest hearing you're ever going to have. 90%, so much of bill collection, I feel like, is designed to scare you, to intimidate you, to confuse you, to overwhelm you. And what all they're doing is having you show up and testify that you don't have anything. Show up. There's nothing to be afraid of. It's just 90% attempt to just kind of shake you, but when you know what they're actually trying to do, you can see that there's really nothing there. They're just making noise at the door. So that's some information about garnishments. I want to talk just very briefly about student loans. Student loans are a little bit trickier to get rid of in many ways. They're not subject to bankruptcy like so many other debts are, but there are 3 other tools that they have, actually 4 other tools if you count the income during repayment options. There's a disability discharge where if a person becomes totally and permanently disabled, then there's a link right here to the form that you can fill out. I believe you can actually do it online now through studentaid.gov. If the school closes while you were enrolled or very shortly afterward to the point where your degree is basically worthless, then that can also be grounds to get it discharged. And there's also something called a borrower defense. And borrower defense has kind of been scaled back over the last year or so. But if there was any type of deception or dishonesty from the school, hey, we're totally accredited when they know darn well they're not, or just something that gives rise to the level of beyond just legal puffery, trying to say, boy, this is a great degree. But something that really hits bordering on range of fraud, then that can also be grounds to get it dismissed. Now, none of those apply. Again, there's always income-driven repayment plans. So many of my clients can qualify for a $0 repayment, and so I'm like, look, get on that. At least you'll be getting credit for your payments. No reason to go into default. I know they're doing some shake-up here with the plans, getting rid of several of them, bringing in one called the WRAP plan here soon. But again, those are just tools that are available now and should be for the foreseeable future. Now that we've talked a little bit about student loans, I want to spend just a moment on medical bills. One of the things with medical bills is they all offer for the nonprofit hospitals. And maybe even let me back up, and I'm gonna maybe get a little bit out of order here with my slides. One of the things that the Affordable Care Act did that I really think didn't get enough credit is there were a lot of nonprofit hospitals that were getting tax exemption and basically saying, saving hundreds of thousands, if not millions of dollars a year on tax relief for being a nonprofit charity. However, when there was an actual investigation of it, it turned out that a lot of these nonprofit hospitals really weren't doing any charity at all. They were just taking large tax deductions without doing any charitable work, despite claiming to be a charity. So what it did is it kind of put a put up or shut up type of thing on them, where they were required to give a certain amount of charity based off of the amount that they brought in. And so, really, to their credit, if not all of them, and certainly the majority, put together financial assistance programs. And it's under 501R, I believe, the tax code, that talks about how they would have to put one of these programs together. So the three big nonprofit hospitals in town, Nebraska Medicine, Methodist, and CHI, they all have these financial assistance programs. I put a link to each of those right there in the PowerPoint where people can click on that and apply for financial assistance. The biggest reason I find my clients get denied is because they didn't apply quick enough. They all have their own rules on how quickly they have to do it. It's, I believe, 6 months to 8 months, depending on the organization. And so biggest thing is apply quickly. Worst they can say is no, right? This kind of touches on what I already talked about, is how they'll have to do that to keep their nonprofit status. There was kind of a famous case right there, the Preventa case out in Illinois, where a hospital lost its tax status, tax exempt status for failing to comply. And so, yeah, they're serious about it. And, I tell the clients, look, they're putting these financial assistance programs in place, partly to help you, but really more to help themselves than anything else. And I don't mean that negatively. I mean, just factually, forgiving your $1,000, whatever bill, pales in comparison to the massive tax hundreds of thousands of dollars they would save on that for being able to be a charitable organization. They're required to widely publicize it, establish clear criteria, and the way that usually goes is there's a little corner in each of their websites, and they do it, or they put in the back of the bill. Again, look out for those and apply for those when and wherever they could be appropriate. Now that we've talked a little bit about medical, I want to spend just a moment talking about scams. Again, I think this might be a little bit off from the rest of the presentation, but that's really just been something that we've been having to deal with quite a bit over the last year. Probably about a year and a half ago, we started seeing a lot of rise in people losing money from Zelle. I don't know if anybody here remembers. Just that widespread problem. I'm still seeing it, people using Cash App or Venmo, sending it to places that they really have no business sending it to. But as an attorney, a scam is a very hard one to try to help with. because so much of the legal system involves one party against another party. And when somebody comes to you and says, hey, I've got this problem, somebody took my money. I have no idea who this person is. I have no idea where this person is. Can you help me get it back? As an attorney, you kind of sit there and say, boy, that's going to be a tough one if I don't know who or where they are. So when I'm talking about a scam, I want to distinguish a little bit between a scam and a ripoff. Now, a scam is something that's deceptive. They're trying to lie to you to get your money. They'll give you probably nothing in return, or maybe something that's just so grossly outside of what they promised. That's what we're talking about. A ripoff, that's maybe something where, and there's a little bit of a gray area, maybe a little bit of an overlap, but you know, they promise this, you get something kind of similar, you know, you bought a car and it just wasn't in quite as good a condition as you were hoping for, or something like that. Usually something like that, I think, is maybe more of a ripoff, but not something where they just take your money and run away, disappear from you forever. Ripoff, at least we know where they are, usually, right? Now, if you paid a scammer, one of the most important things is understanding how you did it and what to do, because time is going to be a very, very important factor. Again, like I said, I have a whole presentation on how to help identify scams, how to, you know, protect yourself against scams. So this one really focuses more on what to do once that money is gone. And whether you paid it through an electronic transfer or whether it was through a credit card, there's going to be a little bit of different laws to protect you. There are, of course, the laws like the Nebraska's UDAP law, the Deceptive Trade Practices Act. And if this is a repeated problem, you can also get the Attorney General involved, and they can be looking at some pretty hefty fines, $2,000 per occurrence. We talked a little bit about the Fair Debt Collection Practices Act. Again, it can be very hard with a scam because they're gone. If they're putting in a credit report, there's laws there to protect you. But this is kind of the next two I wanted to focus on, the Electronic Funds Transfer Act and the Fair Credit Billing Act. The Electronic Funds Transfer Act deals specifically with you and your bank, or the method that you were sending, right? Zelle ended up getting held liable under the Electronic Funds Transfers Act. They were trying to say we're not a bank, and the court ultimately didn't buy it. The Fair Credit Billing Act deals specifically with credit cards, if you end up putting the money on a credit card. And for both of those, the key is within 60 days, 60 days, 60 days of the billing statement. So again, that can be one of the big problems, because if they're any good, you might not know you got scammed until much, much later. But again, if you sent it through like a Zelle or a Venmo or a Cash App, you go and you file an EFTA complaint with your bank or with the Zelle, you know, with the company that you sent it through. At that point, they're required within 10 days to either have completed an investigation and explain to you why it wasn't a fraudulent transfer, or B, credit it for 45 days until that's done. Okay. And if they can't make a decision, then again, you'll be able to keep it. Now, if you're outside of the 60 days, you can always file the complaint. They'll often still do the investigation, but you don't have that 10-day grace period. You can't force them to do it, and you can't get that 45-day credit. Fair credit billing, again, it's very similar, 60-day time frame. We're dealing with credit card companies. You go to the credit card and you file the complaint through them. Again, my biggest thing is if you got scammed, report it, tell it, be loud, go to the FTC, go to the Nebraska Attorney General. There's the link to both of those there. And make sure that if you got burned, you tell everybody about it so that more people don't get burned. The quicker we can stop those, the quicker we can make it safer for everybody. So now that we talked a little bit about scams, I want to jump to foreclosures just very briefly. Talk about some laws that are there to protect individuals who are going through foreclosure. And I want to talk a little bit about what does the process look like, because so many people get very, very scared with foreclosures. And again, I have a whole nother presentation on foreclosures. If anybody wants to see that another time, you can always reach out to me. But in Nebraska, there's really two different methods for foreclosure, either judicially, meaning through the court system, or what's called a non-judicial foreclosure. Now, keep in mind, you can't begin the foreclosure process until the borrower is at least 120 days delinquent. If they were to go through the court, they go through the same normal process. You file a complaint. You have to let them know about it. If the person wants to file an answer, they can file an answer. If not, you get a default judgment. If they do file an answer, you get through the basic discovery phase, eventually a trial, and then a judgment. And then at that point, they can sell the house in as soon as 20 days after the order. A non-judicial foreclosure is where it doesn't go through the court system at all. Most of the time it goes through what's called a trustee, which is typically represented by a law firm. But once the person is at least 120 days delinquent, they'll get what's called a notice of default. And that's a certified letter that they get in the mail that says you have 30 days to catch up. And if you don't catch up, we'll begin with the foreclosure process. Now, if the person does not catch up, what exactly does that mean, begin the foreclosure process? Well, it means that they have to put in the local paper for 5 consecutive weeks when the sale is going to occur. And at the end of the 5 weeks, if the person hasn't gotten caught up, then they'll have the sale. And keep in mind, once the sale is done, there's not a lot you can do to undo that here in Nebraska, barring maybe a showing of gross fraud. So if a person comes and they're beginning the foreclosure process, again, I always recommend know where you are in the process. Just understand what's happening, where you are. Are we at the notice of default? Has it been getting published? Is there a sale date? Just so we know exactly what type of time frame we're looking at. And at this point, you have to really have a heart-to-heart with the client to say, look, at some point, and I hate to get this blunt with it, but at some point it really comes to either you got to figure out a way to pay it, or you're going to have to get out. So to pay it, whether it's if it's a judicial foreclosure process, it's what they call a redemption, where you get caught up. Non-judicially, they use the term reinstatement. You get caught up in it. Working it out with a lender. A couple of different options, and there's actually even a few more options than this, but you can ask for what's called a deferment, where they just basically say, cool, let's just extend the life of the loan. Let's put it all at the back and just keep payments going forward and make every payment. There's another one that's called forbearance. A lot of times people use these terms interchangeably. They are a little bit different. A forbearance is when they'll say, okay, you don't have to pay for a certain period of time, and then we'll do some type of a payment plan to help you get caught up, right? Don't pay $1,000 this month, but we'll just increase your monthly payments $100 a month for 10 months. There's also what's called a loan modification, where your current lender just cuts you a new loan, a new 30-year loan, right? Of course, be cognizant of interest rates and what your monthly payment's going to be before you go into that. There's also something that's called a partial claim with a loan modification attached, and that's kind of a neat little process. I don't know if I'll get into a lot of it. I don't have a ton of extra time here. But that's just basically a way where they could do kind of a partial mortgage insurance claim. It's more for government loans, where they'll basically allow a partial mortgage insurance claim to reduce the amount, and then they just modify it for their. I'm sorry, I'm confusing that. If you can't work it out with the lender, then you can borrow the money from another bank. Call it a refinance. A lot of times I hear people say modification, refinance. They use them interchangeably. Technically a little different. Modifications with your current and your refinances with a different one. Now, if you can't get the lender to work your way through it, you can't borrow it from someone else, you can't get caught up. Sometimes another option is to do what's called a Chapter 13 bankruptcy. And I think with that, that's a pretty good segment into my next slide here. Bankruptcy as an option for low-income individuals facing debts. So what exactly is bankruptcy? It's basically a set of laws. It has two main purposes. It's a fresh start for the debtor and an organized payment method for the creditors. Right? There's a Chapter 13, that's a payment plan for 3 to 5 years. Or there's also what's called a liquidation. Now, in the instance of a mortgage, essentially how it would work is you would just tell the court, hey, look, I'm behind X amount. What I'm going to do is I'm going to pay that full amount through the plan to the mortgage lender. And if you can make all of your payments in your bankruptcy, as well as stay current in all your mortgage payments going forward, then you're going to get totally caught up and they have no reason to complain. Again, that's a big math question of whether that can be feasible. But if you can, thread that needle just right, that can be a good way to save a house. A liquidation, there's no payment plan. Excuse me. It's just the court says, well, do you have anything that's worth a bunch of money? And if the answer is yes, then they're going to take it and sell it and divvy that out equally to everybody. And if the answer is no, you don't have anything, then they just, everybody shakes hands and goes their separate ways. As soon as you file, the first thing that happens is the court sends out an order telling everybody to stop. It's called a stay order, stop all collection. They do it automatically the minute you file. If you ever do a search bankruptcy, you see the term automatic stay, and that's what they're talking about. And that's going to go into effect until, hopefully everything goes right. If something goes wrong, the case gets dismissed. That's unfortunate, but if everything goes well, you get what's called a discharge. And a discharge, it's just an order from the court saying they can't force you to pay it. And really, most things will. It's more the exception to the rule that won't, child support, criminal fines, intentional injuries, dishonesty, theft, fraud. Taxes, usually not. Student loans, usually not. But really, even having the threat of a person going into bankruptcy can be quite a powerful game changer when it comes to negotiation. So at this point, really in conclusion, I hope I kind of dispelled a little bit of that. I often feel like one of the worst parts about debt collection, it's not even the math. It's just a constant drip, drip, drip. There's just that anxiety that goes with it. And, what's going to happen? What can they do? And once you kind of clear that up, you realize, hey, maybe there's nothing they can do at all. Or maybe, they can take 15, 25% of my wages. Okay, if you can afford it, great. And if you can't, well, that's, maybe we're negotiating or a bankruptcy might come in. Ultimately, prepare, pay what you can, prioritize when necessary, apply for financial assistance whenever and wherever possible. And just understand, we have laws out there that protect you. We have the FDCPA. We have these garnishment laws and other execution laws. There's bills that allow them to try to collect, but there's also laws that protect you. So they can't kick you out of house and home and rip the shirt right off the back. So just understand that at the end of the day, you're going to be okay. And if you can't afford the garnishment or something like that, then yes, bankruptcy can be a very powerful tool. And with that, again, I'll just kind of leave you right there. And again, just say thank you to the Nebraska Council on Economic Education for letting me be here. My contact information is there in the slides. And you can always reach out to me or reach out to Matt or Jennifer, and I'm sure they can point you in my direction. And thank you so much, and I wish you the best.